Hello, my name is Stephanie Kelly and I'm a partner at Ice Miller in Chicago, where I practice management-side labor and employment law. Today, I want to talk to you about one of the most tricky issues that anyone who works in HR or employee relations or operations for that matter encounters when they're dealing with their employees. And that is particularly employee leaves and absences, or as I like to refer to it, off the grid, do you know where your employees are? Any of you who work in or are involved on a daily basis with managing employees understands that dealing with leaves and absences can take a lot of time, can be very complicated. And part of the reason it is so complex is because medical situations are at the center of a myriad of federal and state laws, and it can be difficult for an employer to know which law to look to as a guide or reference, or which to apply in every situation. So, for instance, we know that when employees have medical issues, certain laws can be at play. The Family Medical Leave Act, Americans with Disabilities Act, even Title VII of the Civil Rights Act, which deals with preventing discrimination for individuals in a protected class. But more than just federal laws, there are several state laws, including here in Illinois, the Victim Economic Security and Safety Act, as well as workers' compensation laws, and the newly amended Illinois Human Rights Act, which provides certain protections for expectant mothers or pregnant employees or applicants. Layered on top of all of the complex federal and state laws at play, you also have your policies. If you have a unionized workforce, your collective bargaining agreements. And for medical issues, your short-term and long-term disability plans. It can be quite confusing when you're confronted with all of these different areas of the law to understand or know where to go when you're confronted with medical situations for your employees. So, today, I'll take you back to high school. We're going to do a quick pop quiz, and I'm going to trust that you will mark down your response, and your prize for hanging in on the video will be the correct answer at the end. So, our pop quiz today, it's Monday afternoon, and Carla, who is pregnant, just called from the hospital to tell you that she wouldn't be at work today because job stress has caused pregnancy-related complications. She also told you that she might have to be absent at work for the rest of the week, possibly longer. What laws and policies are implicated by Carla's call? A, family and medical leave. B, medical or disability leave. C, workers' compensation leave. D, leave as a reasonable accommodation for a disability. Or E, leave as a reasonable accommodation for a pregnancy-related condition. Keep in mind your answer, and we'll get back to it at the end of our presentation today. I have 3 small objectives for today, and hopefully they're not too ambitious, but 1, that you will recognize when a request for a leave of absence beyond the FMLA is a legal issue under the Americans with Disabilities Act. 2, that you'll be able to analyze facts to determine whether a possible ADA violation exists at all. And lastly, that you will be comfortable with options when FMLA has expired or does not apply. So, as a quick reminder, it's important to remember what the Family Medical Leave Act and what the Americans with Disabilities Act, what they actually provide and what protections they offer to employees. So we know that FMLA provides unpaid job-protected leave for 12 work weeks out of a year. The requirements being that that individual will have had to have worked at least 12 months and a minimum of 1,250 hours in order to qualify or be eligible. That leave can be intermittent, so while typically when we think of FMLA, we'll think of something like a maternity leave where an individual may take a month or 2 or 3 and concurrently. Leave can be intermittent, so it can be a week, it could be a day, it could be part of a day. The key to remember for FMLA leave is that it protects that employee's job. So when an employee does take that leave, they are entitled to be reinstated to their same position or an equivalent position. And that's really what the underlying protection of the FMLA is. Moving on to the Americans with Disability Act, we know that the ADA protects individuals who are either disabled or perceived to be disabled from discrimination on the basis of that ability, and allows them to work with a reasonable accommodation. So it prohibits an employer from discriminating on the basis of a disability, and it requires the employer to engage in what's called the interactive process to find what reasonable accommodation can be made so that employee can do their job. The difference being between the ADA and the FMLA is that it takes effect on day one. There's no threshold requirement that you have to be with the employer for a year. There's no hour requirement. So if you hire an employee and the next day they tell you that they have a disability that requires accommodation, you're obligated as an employer to engage in the interactive process. Most importantly, the ADA provides accommodations for employees' disabilities only. So whereas under the FMLA, an individual can seek leave for their own serious health condition or the serious health condition of a spouse or close family member, the ADA only protects that individual. And just as a quick aside, there are probably 5 or 6 ways where the rubber hits the road when it comes to these types of claims. As a part of my practice, I also litigate. I defend cases that are brought under the ADA and the FMLA on a regular basis. And these cases usually come from a misapplication of policy or law or both, and usually spring from one of these things on the list here. Denial of a promotion because of absenteeism. Termination because of excess absence. If you have an attendance policy, the abuse of which would lead to a possible termination, and an individual who either might have qualified for FMLA or ADA benefits, but that has not been explored and they're terminated for violation of the absentee policy or the attendance policy, excuse me, that can be a touchstone or a point where litigation may ensue. Likewise, a denial of a request for a leave of absence, or a situation where an employee has been terminated, demoted, or denied a promotion because of a failure to meet fixed production targets. Lastly, a termination because the employee has used all of their leave and needs to continue to use leave. So what do you do when you're confronted with an employee who may or may not be eligible for FMLA or ADA? Here I have a checklist of questions and/or issues that you might use to spot to determine whether or not an employee would be eligible for benefits under the FMLA or the ADA. First, is that employee eligible for time off? So for instance, we know under the FMLA, there's the requirement that employees have to have been employed for 12 months and a minimum of 1,250 hours. If it's a new employee who's only been employed for 3 months, they may not be eligible under the FMLA. How much leave does the employee get and in what form? This will largely be dictated by your policies. And the important thing being here that you need to be consistent in your application of these policies for like conditions and like positions. Another question that might be helpful in determining whether or not FMLA or ADA is appropriate is whether or not the leave is paid or unpaid. Oftentimes what you'll see is that even for an unpaid leave, a company can and is completely right to simultaneously use their vacation and or PTO policy to offset the leave. What happens to the employee's benefits? Under the FMLA, there are benefit continuation provisions which will allow the employee to continue to pay for those benefits while they're on leave. If it is an employee perhaps who is on some type of long-term disability, when does your obligation to continue to provide benefits cease? Do you have to hold the employee's job, and for how long? Let's say an employee goes on leave and is expected to return after 2 months, but after 3 months the employee hasn't returned, and after 4 months that employee still hasn't returned. It's important to figure out, and again, this is going to be dictated on whether or not this is FMLA leave, or it's ADA leave, or it's a leave for another state law, how long you have to hold on to the job. Do you have to offer light duty? And what happens if the employee comes back with restrictions? What are your obligations as an employer? The big one, the one that I have highlighted here, is what happens when the employee runs out of FMLA leave or never qualified for it in the first place. And that is always very interesting, because if the reason why that employee is on FMLA leave is because of their own serious health condition, and the last one that I have highlighted here is what happens when the employee runs out of FMLA leave or never qualified for it in the first place. It's important in this situation to understand why that employee is out on FMLA leave. If it is for their own serious health condition, a smart employer wants to ask whether or not that serious health condition would be considered a disability under the ADA. And if so, does that kick in on your obligation to engage in the interactive process and determine what reasonable accommodation, if any, can be made? And there have been several instances where continued time off can be considered a reasonable accommodation under the ADA. So you've asked those questions, you've done the work, and you've done some issue spotting. But what if you suspect that your employee is abusing their leave? There are a few possible patterns that we see time and time again. Employees who are out on Mondays and Fridays routinely. Or employees who refuse to work overtime or on the weekends, or they possibly have a second job during work hours. The important thing to note here is that if you have a documented pattern of absence, that will allow you to communicate with the employee's healthcare provider about these patterns. For example, you have an employee who has diabetes and has used FMLA leave to care for their serious health condition. When they're returned to work and have been certified to return to work by their medical provider, but then you start to see attendance problems with that employee. The employee calls off multiple times a week. You want to look at that certification from the medical provider. Does it say that that employee will have to call off because of management of her diabetes? If the medical certification says the only time the employee won't be able to work is when they're coming to visit their doctor every 2 months, then it would be fully and completely appropriate for you to reach out to that healthcare provider about this pattern to see whether or not it's consistent with their certification. So, what do? You request a new certification of eligibility for that employee. Or if you're convinced that it is not an FMLA absence, then you treat it accordingly under your attendance policy. And if discipline is warranted, that you would go ahead and proceed with that discipline. The answer is there is no safe zone outside of the FMLA. The EEOC, as well as various state agencies, have long maintained, and they're now aggressively enforcing, that you may have leave obligations to your employees regardless of whether or not you're covered by the FMLA, and regardless, of what your policies say. Here I've identified some common and what can be costly pitfalls in the FMLA ADA context. The first is employers often are waiting for magic words, but it's very rare for an employee to raise their hand and say, I have a disability, can we engage in the interactive process? I need a reasonable accommodation. More often what happens is a manager observes a problem with an employee, or a coworker will come and report an issue with an employee, or there have been excessive absences that lead to questions. But where an employer makes a huge mistake is waiting for an employee to use the magic word disability or accommodation or FMLA. Sometimes employees don't know what FMLA or ADA is. Other things on this list, and we'll just highlight a few. Our policy, we're sticking to it, we're not making an exception. Well, both the FMLA and the ADA are full of opportunities for you to make exceptions for your employees. And in fact, it is expected that you will if it's reasonable and doesn't incur an undue burden on the employer. Telling an employee that you can't do this job. Well, is it that the employee can't do the job the way that it is, or there are accommodations or things that can be done that are reasonable that would allow the employee to do this job? Things to think about when you're interacting with your employees around leave issues. A big one, and one that too many employers fall into the trap of, is not talking to the employee during the leave process or at the end of the leave process. You really need to understand what's going on with your employee, and just assuming that they're going to come back to work when they said at the beginning of their leave can cause a lot of problems down the road. And lastly, there are various confidentiality issues that come in with dealing with anyone's medical information. And you want to make sure that conversations dealing with an employee's medical condition need to know and only involve the individuals, ideally someone from your HR or an employee relations department, to talk about those. Lastly, and most importantly, there are various confidentiality issues surrounding an employee's medical condition. And it's really important as employers that information that is shared about an employee's medical condition are shared with only those who need to know, primarily individuals in your HR or employee relations group, and perhaps the manager, but not always the manager. So now that we've identified the problems, let's talk about a few practical suggestions for how to deal with the overlap between the FMLA and the ADA. First, update your policies to include flexible cross-referencing language. 2, communicate with employees before, during, and after medical leaves of absence. You also want to make sure that you request medical documentation and any other application paperwork consistently. It's really key. You want to make sure that you have a dialogue between you, the employee, and the employee's medical provider. Next, no single person should make the accommodation decision in a vacuum. You want to have a centralized decision process, one that involves the key folks that need to know, and we just talked about that, someone from HR, possibly the manager, and the employee. And I can't emphasize this last point enough. Make sure that your first line supervisors and managers know about these policies. They should be trained on what it means to take leave under the FMLA, what a reasonable accommodation means, so that, because they're the ones who are going to spot these issues first. And they should be your partners in making sure that your employees are able to benefit from the protections of the law. Last, but certainly not least, I often get calls from clients who are frustrated because the leaves tend to lag on. And it's important to know that leave may be a reasonable accommodation, but there are other types of accommodations that might also solve the problem. Modified flexible schedules. Maybe an employee needs time at the beginning of the day to manage their condition, and they can come in later, or work weekends. These are things that should be explored. Or work from home, work remotely. Are there equipment or devices or ergonomic adjustments that can be made to help the employee do their job? Or could you provide a temporary modification of job duties? Importantly, extended leave, while it may be reasonable, eternal leave is not a reasonable accommodation. And so if it becomes a situation where the leave has gone on and it seems to be indefinite and there seems to be no end in sight, it's important to take stock and reevaluate what in fact is reasonable in that situation. Because termination may be an option when employees do not participate in the process, or if they have no reasonable likelihood of returning to work. We're back to the pop quiz. What is the answer? What laws and policies are implicated by Carla's call? Well, I think any of you who are moderately adept at doing some issue spotting here probably answered or thought to yourself, all of those are implicated. And if you did, you're right. F, which I know wasn't an option at the beginning, all of the above is correct. So if you disagree that F is the correct answer, or you have an employee like Carla who you believe may be abusing leave, feel free to give me a call or shoot me an email at the contact information provided, and I'd be happy to talk to you. Thank you.